Let's see.
Ain't I've been going.
Like been lit just how I want it. Yeah.
Common sense
Yeah.
in the building.
Now she talking like she want me. Yeah. Hey. Wave.
She said, so you
Yeah.
no. Sometimes you can't comment. So, anyway, let me turn this off. Right. You most definitely got to be subscribed. It's too much riffraff. You know, people mad. Alvin in the building. What's up with you? What's up with you? They mad, Alvin. They mad because you either got to be a member or you got to be a subscriber. They mad. They hot. I'm getting all kinds of comments. Mad. Boy, they mad. Yes. So, let me get my shout outs. Let me get my shout out. Shout out Alvin. I forgot where you're from, Alvin. Shout out where you're from. Shout out Fresno Bay. That is, Los Angeles, Inglewood, where it's good. Long Beach, where I lived for like 10 years or something. Tampa. Shout out Tampa. Shout out Tampa. Florida. Shout out San Diego. What else? Lompoc. What's the other? Lancaster. Cheap. Orange County. That's where you move to if you want to be a Republican in California. That's an anomaly. A Republican in California is like an anomaly. Although they was running the show for a while back in the day when what was the name of that dude? I forgot the name of that dude. That's where Trump's guy. What was his name? Uh, the one that kept sliding in on his meat from California too. Um, this is the Hood Trucker Show, and I'm the Hood Trucker, and we're talking about the parents of them people, of that shooter that went over there in Michigan and shot 100% ridiculous. Like, you know, if son better than you do, I mean, in other words, you know your son, and that's why they charge that ass. And you know, we gonna the court hearing today, or was that today or yesterday? Um, but you're gonna hear a lot by way of what I'm gonna call white. They basically hold on, let me see. Is my internet tripping? Can y'all hear me? Is my internet tripping? Am I froze? Am I froze? Y'all let me know if I'm frozen. Let me turn it down some more. So check this out. We gonna watch. No, we gonna watch, but we gonna listen to the you know it's this like you got to be careful because Bluetooth be crossed up and all kind of stuff, and you get to crossing up too much stuff and you know. Oh, by the way, did you hear about did you hear about them finding a whole bunch of money in Joel Osteen's wall? That's crazy. That is crazy. Weak Biden. A bunch of money in Joel Osteen's wall at the church. That's crazy. What you doing with all that money in the church? What you doing with all that money in the church? Let's see. Okay, so we're gonna pull this up right here. Yeah, this is the we gonna listen to we're gonna listen to the we're gonna listen to the arraignment for the shooters on for the and because again I can't share the screen. I'm on mobile and I'm on mobile and I can't share the screen. But let's answer this question right here. Games and rest. Welcome. Where Maryland at? Maryland is minding her mother. That's where Maryland is at. That's where Maryland's at. Games and rep. So check this out. Let's go ahead and go ahead and listen to this arraignment because it's telling. There's so much going on here in this arraignment. I don't know if y'all had a chance. We're gonna listen to it because I can't see my screen again on this mobile shit. But you know what? Let me turn this off too. Let me turn this off so y'all can hear better. Shit, hooked on my watch. Sometime, man, it's crazy. Let's go. Let's go. Let's listen.
First, I'm going to start with Defense Counsel Marielle Lehman and Shannon Smith. You hear the court? Yes, Your Honor. Good morning, Judge. Okay, Mark Keast from the prosecutor's office. Can you hear the court? I can't. Jeff. We're still giving you good. James Crumley, can you hear and see the court?
Yes.
Okay, Karen McDonald, can you hear and see the court?
Good morning, Judge.
I'm going to call starting with People versus Jennifer Crumley, docket number 2100652. Can I have appearances on the record, starting with the prosecutor?
Karen McDonald, on behalf of the people of the state of Michigan.
Mark Keast on behalf of the people.
Crumbley. Good Honor, Marielle Lehman on behalf of James Crumbley.
I do want to address one issue first. In the same firm, is that correct?
Okay. I don't know how well or how versed y'all is in the court arena. Like I fought my own case, so I'm pretty versed. Salute, David Dundee. Salute to you. Salute to you. Um, so I'm gonna kind of like for all the people that are not really familiar with court cases and arraignments and stuff like that. I'm gonna kind of stop it from here from time to time, kind of let you know what's going on. Uh, What's about to happen? Apparently, they have like it's two defendants, so they're what's called co-defendants, or in the jailhouse and prison world called Code D. So anytime you have a uh, uh, involved in the same case, have public defenders, what they have to do is they have two defendants that's represented both by the public defender's office. That's why they go out and they hire outside attorneys to represent people on the right. They're afforded an attorney, but if both of them can't be represented by the same office, which means that if it's a public defender's office, they have to one of them have to be represented by a private conflict of interest. I never understood the conflict of interest concept because I don't know what the conflict of interest is, but it is a conflict of interest in the court's eyes, and you're supposed to separate that. Um, see, Alpha Buckeye, the internet choppy. I mean, that's I I apologize, but it may get better. Hopefully, let's hopefully it gets better. That's what they're about to discuss, and they're about to explain why it forward with the fact that both of these defense attorneys.
Your Honor, the science about conflicts of interest. We have had in-depth conversations with them. Marielle Lehman and I are representing both of them. We are representing and Jennifer, and the conflict of interest question or issue has been very much discussed, resolved, and we believe at this time ethically and professionally can continue on in this fashion.
Okay, so they basically saying they'd already talked to them and all that, and they got it worked out, and they don't mind being. Now they were on the run. They said they weren't on the run, but I mean, if you don't turn yourself in, you I don't know how you can't classify as anything but on the run, because they had to be apprehended. They didn't turn themselves in; they had to be apprehended. First, get arrested fast because I think it was. I'm assuming that it happened today. If it was 10 hours ago, I never seen an arraigned. This is a very high-profile case. It's also happening on Zoom. I mean, I think that it happened today, so which is Saturday. So that's telling. Never seen an arraignment on a Saturday. Happened 10 hours ago. Then I was let's see, Central Time. It's 8 o'clock. Michigan, is that Eastern Time or Central Time? So let's assume that it's Eastern Time, which is 9 o'clock. It was 10. Happened on a Saturday. I've never seen an arraignment. So that's telling.
Well, as you know, pursuant to NCR 6.005 subsection F1, you must state on the record the reasons that you believe joint representation in all probability will not cause a conflict of interest. So please state that for the record in accordance with the court rules.
Thank you, Your Honor. After reviewing and one of the things that has very much been sad, cherry-picked facts, but when we circumstances of the case, which obviously are covered by attorney privilege, there is not a conflict of interest between what happened. Without, I cannot divulge to you the specific reasons, but there is not a conflict of interest between the parent strategy.
Now, the reason why they just got some lawyers and they they got some lawyers and they got a deal or something out of the same right. Uh, they were out in the building. Right. Which was crazy. Was crazy they caught them in the building in Detroit. Yes. What's crazy is the explanation. Right. And here's the thing. Um, said that there was text messaging on one of the incidences or something, and they had it was when the uh the the kid searching ammunition in class, and they alerted the parent, and they said this dude your son is over here looking up ammunition. Bonded text the son and basically said, you need to learn how to stop getting caught or something to that effect. And then it was a LOL. Well, there was an old man uh, on one of my cases that he was a homeless dude and he was fighting to try. I get why he was doing that. It was cold, it was wintertime. You taking a trial. I was on a drug case. So it was pretty much all non-violent type of a sale, a tank or whatever. And this dude, he had a saying because there was other people in there, young like this is I probably in my I don't know late teens, early 20s, maybe. No, it had to be. No, I was in. And so there was some younger dudes. Like you got to be 18 to be there, but there was some younger dudes, and they were just like, they was having fun all the time, laughing. And he had a saying that he was saying like he was saying it was crazy, it was funny as hell, and he would say to talk to the youngsters, he would say, "Y'all laughing now, but you ain't gonna be laughing when they slap that time on your ass." So that came to mind when was over there, LO and talking about stop happens later, charges that they put on there, and how much time each one of them charges. You gonna see what that classic.
Peter, any comments or statements you want to make relative to any potential conflicts of interest?
Your Honor, I'm not sure that there's any facts that have been placed on the record that meets the standard. I'm not saying.
Is that in order to get past the conflict of interest, they have to prove or they have to explain why it's no longer a conflict of interest. Based on attorney-client privilege, we can tell you what why it's right. They hide behind that. Excuse me. And the process we've meet the thresholds. I don't disagree though, but I'm just for the record because you have to put everything on the record. For the record, I don't think we've establish that because you never know, when you can use this to your strategic advantage, right? This right here. So you have to get everything on the record, even if it doesn't. You don't think it matters at the time, because if it slips by you and then you need it later, that's a missed opportunity. So that's why the philosophy is I'm gonna talk about it now. If it helps me, harm no foul. That's why she said I don't agree that we have met the standard that we need to meet, but I don't disagree. If you want to go ahead and go, I'll agree. And that's because she's like, okay, what's up, BB Cross? It's, but I don't think we met the threshold, and she's saying that just to put it on the record. She's like, if you really get into these court cases, shit on the record, like, hey, I said on that all based on laying everything out so you have something to refer to. That's all it is.
If Mr. Keast has something to add.
I am required to inquire as to Ms. You and Mr. Crumbly for this case from the same firm, and they will be representing both of you.
I have no objection.
And this is another thing that the court, this is all like a lot of just procedural stuff. They have to not only talk to the lawyers and say, hey, it's a conflict of interest. It's not a conflict of interest. Then they went to the prosecutor and say, hey, would you threshold? But I don't disagree because she feel like she finna smash him anyway. And then now they talking to the each that both and that we go the conflict of interest issue, and it's all procedures, all just for the record. They want everybody to speak on it, so there's no question as to you agreeing within your like the defense team. There's no conflict of interest. I don't think we met the threshold, but I don't disagree. I'll let you go forward, and then now we're talking to the defendants.
Mr. Crumbly, likewise for you. Do you have any objection to both Ms. Lehman and Ms. Smith representing both you and Ms. Crumbly as it relates to the case?
No,
Do either of you have any questions or concerns? Mr. Crumbly?
no.
Okay, at this
Now, the judge is all business. She's saying, okay, look, the conflict of interest or any potential conflict of interest in the future, do you think? Ask them both. Yes, yes, no, no. She on the job.
We're satisfied that both of the defendants are comfortable with both attorneys representing them in the case. The attorneys have indicated on the record that they do not believe that there's a conflict. They have spoken with both defendants in depth relative to any potential conflict of interest and whether or not the representation recognizes the right of each defendant to have the undivided loyalty of their lawyers. The court will allow them to appear for purposes of the arraignment today. Both defendants.
Now you see what she just did. She asked, like she said, she presented the issue. She asked the lawyers, she asked the prosecutor, she asked both defendants, and then she came back and explained what just happened. She is on her mother. Yes.
Now, in terms of the arraignment, Jennifer Crumbly, I'm going to arraign you first. So please make sure you close that microphone so that we can hear you. If at any time you cannot hear or see me, please put your hand up and we will stop What's going on? Do you understand that you are charged with the following counts? Count 1, involuntary manslaughter, which is punishable by up to 15 years in prison and or $7,500 fine, and mandatory DNA for the death of Madison Ball.
That's when that motherfucking reality sets in. She said, "Do you realize you're being charged with count 1, involuntary manslaughter, and it carries 15 years and $7,500 and all of that?" That's when reality hits you. That's when you understand, like, what the fuck did I just do? Look, I mean, it's 4 counts. It's 4 counts. You of all 4 counts, the judge got discretion. We can run these motherfuckers concurrent, which means that if you get the maximum, let's say maximum 15 years, it gets 15 years. If you run them concurrent, then you're doing 15 years. That means that they're stacking all 4 counts on top of each other, basically. So you got, even though you got 4, you're gonna do the equivalent of 1, and that's why, excuse me, in this particular case, that if you if they get convicted of all 4, or if you get convicted of 1 because you were charged with 4, it's a good lot to get the max. You might get the max anyway, however it go. And the max being, I'm gonna do you a favor. If you're convicted of all 4, I'm gonna do you a favor and run concurrent. You only do that favor, right? If it turns out that there's some extra evidence that makes it more egregious, makes it more sinister, makes it more, I think they call it, what is it, mitigating factors, whatever. Then they could say, okay, we're running these consecutive, which means when you do that first 15, you do that second 15, then you do that third 15, then you do that fourth 15. That's 60 years. That's the difference between consecutive and concurrent. If you get 4, you're doing 15 on the max, right? If you're doing consecutive, you're doing 60. And your demeanor in court, what the facts of the case was, all kinds of different factors. And she watching. I don't know if this is going to be the trial judge necessarily, because sometimes the pretrial proceedings, sometimes it switches judge. Like you might have an arraignment judge, then you go to preliminary hearing. You may or may not have the same judge. Then you go to trial, then you may or may not have the same judge. So it just depends on how big the courthouse, the city, all that, a lot of different factors, but state, all that. Who knows? But she finna get a slap in the face. You gonna see what happens. She about to get a slap in the face with reality, though. I done been there. I know.
Do you understand that that is a count 1? Mr. Hubley, you need to do you understand that you are charged in count 2, involuntary manslaughter, which is punishable by up to 15 years in prison and or up to a $7,500 mandatory DNA.
Oh, you want to start crying now? Oh, see, it ain't fun and games no more. Remember that text message? Remember that text message you sent and said, you need to stop getting caught, whatever your son's name is. It's fun and games then, right? Not so much fun and games now. Let's continue.
You understand that you are charged in count 3 for the death of Hannah St. Juliana with involuntary, which is punishable by up to 15 years in prison and or up to a $7,500 fine, along with mandatory DNA testing. You understand that you're charged in count 4 for the death of Justin Schilling with involuntary manslaughter, which is punishable 15 years in prison and or up to $7,500.
Understand.
Do you understand that you can
How about follow your own advice and don't get caught? Says I should be an attorney. I can't even pull it up. I can't pull up nothing.
not guilty to all those counts?
I understand.
Jury or by judge, and at that trial, you would have the opportunity and then you'd be presumed innocent until proven guilty beyond a reasonable doubt.
Yeah, Your Honor. Yes.
Are you on probation or parole for any?
Not guilty. Not guilty.
How are you pleading? How are you pleading to count 4?
Not guilty.
The court will please not guilty for you for all 4 counts. Which is going to be on December 14th. What time did we have that one? You could do 9. That is December 14th at 1:15 p.m. The preliminary examination is scheduled for December 22nd at 9:45 a.m. Those will be in-person hearings.
Your Honor, just as a matter of fact, are you assigned for the purpose of exam and the pre-exam, or is it?
So remember what I said, that it could be a different judge. The defense attorney is trying to find out if we're gonna have the same judge or we're gonna have a different judge. Just for that, she might have a reputation. She might, who knows? Like she might want to file something like change the venue or anything like that. What's going on with this judge and whether or not she gonna have the same judge or not. That's why she asked the judge, you gonna be here? That's just us.
Just me.
Okay, thank you. Thank you.
I'm gonna address bond in a minute. I'm gonna go on Mr. James Cromley first.
Thank
Mr.
you.
James Cromley, here, see and hear the court, okay?
Yeah.
And do you understand, sir, that you are charged 15 years in prison and or to a $7,500 fine for DNA testing?
I understand.
Do you understand in count 2, you are charged with the death of Tate Meyer for the involuntary
Understand.
the death of Anna St. Juliana, with the involuntary manslaughter, which is punishable by 15 years in prison and up to a $7,500 fine. Understand that you were charged in count 4 for the death of Justin involuntary manslaughter, which is punishable by up to 2 years in prison and up to a $7,500 fine and mandatory DNA testing.
I understand.
I'm laughing because these people really thought it was a good idea to buy an underage son. I don't even think he has his license. He most definitely can't buy no alcohol. If you're not driving, you can't buy no alcohol. And what kind of parents with guns? That's like I mean, I mean, uh, if you can't drive you know, why you got a gun? Guns are made to kill people. They say guns don't kill people, people kill people. Yeah, but use a gun while you're at it. So what the hell you want to do? Get yourself a car so he can learn how to drive, so he can drive his ass to a fucking job instead of buying him a fucking gun. You're all wrapped up in the NRA and gun rights and all that, and I'm gonna buy my son a gun. The Kyle Rittenhouse bullshit, right? They should have charged him. You know what I'm talking about? But no, that ain't what they did. That ain't what they did next, because they had a whole bunch of money behind. Lamont in the building. What's going on with you? FYF Sports. Uh, with Doug Collins, I missed it. I know you said. I think you said the fourth, second, or the third. So, if you did, go ahead and drop that link if you want to in the chat, so we can all go take a look at it. But yeah, go ahead and drop that link if you know, did that interview. But yeah, he's coming to the stuff. He's talking stuff. You can hear it in his voice. You can hear it in his voice. But you should be. You should be like voice crackly, because you didn't fucked up. You didn't fucked up.
You have the right to plead either guilty or not guilty to.
Which would bring me like the you done fucked up. You done fucked up.
I understand.
Do you understand you have a right
I understand.
to a trial? You have the opportunity to call witnesses on your behalf, confront witnesses against you. And then
I understand.
are you on probation or parole for any other offense?
No,
How are you pleading to what?
not guilty.
How are you pleading to count two?
Not guilty.
How are you pleading to count three?
Not guilty.
And how are you pleading to count four?
Not guilty.
So I almost said something just now. To be in prison for life, or worse, they could have prevented those families from having buried their children. You're gonna hear why. You're gonna hear why. It's so fucking stupid. They should get into their ideologies and get the fucking, you know what I'm saying, to get the, you know, pushing their ideologies on these kids. They ain't not even developed yet. You buy them a fucking gun. And what you as they should. As they should.
Set the plea of not guilty for all four counts. This will also be scheduled for a probable cause conference on December 14th at 1:15 and a preliminary examination on December 22nd at 9:45 a.m. First, I'd like to hear from
pretrial services. Ms. Gardner declined to speak with pretrial services and request to speak with her attorney. As a result, no references were
And then for no reference, that's a dumb, and you're trying to get out of jail. Unbelievable.
Person address with the jail is 112. East Street in Oxford, Michigan. Does not have a history found to appear. Does not have a prior documented history of violence. The charges against the defendant are severe, and those charges issued by the court. Well, every defendant is afforded the presumption of innocence. The purpose of bail is to ensure and the safety of the community. Defendants in this matter had agreed through their attorney to turn themselves in to the court once charges were issued on 12/3 of 21. However, instead they fled based on the concerns for appearance and the safety of the public. There's a recommendation that a release on recognizance bail is not appropriate in this case. In order to further mitigate release, the following conditions are respectfully recommended. Pretrial services supervision, a GPS tether prior to release, allowed to leave home for work if employed. Visits, not to victims that must turn any firearms in that have not been.
Thank you.
They said the charges were issued on the 3rd. They just and they told services said they fled so far. To that, so this is the first mention. That's how they determine whether or not they don't let you out on OR, which is he said on recognizance, which means like they did. He had a 10,000 free. Not only because you didn't, let alone you was over there. They had to apprehend you, which means you didn't necessarily just come in willingly. We had to go get that ass. So you not getting out on own recognizance. No.
Who is going to speak on behalf of the prosecutor's office?
I am, Your Honor. Swear to considerations of the likelihood of conviction first. Here, the likelihood of conviction is strong. Your Honor,
She already said the likelihood of conviction is strong. Like, even though I've been, and I got so, it's so interesting because I had to learn all about it, right? And all that, and it's fascinating how all this shit works. This shit is like, football play. BB Cross said I should have been a lawyer. I should have been a fucking attorney. You're right, but I fucked up.
presented at the swear to that Mr. Crumbly purchased this weapon for his son. And that on the 27th, Mrs. Crumbly went to the shooting range with her son, posted on social media saying that it was a mom and that she was
And you bought a weapon for your miss. Now that's where all the fun and games. Oh, it's all laughy, hee hee ha ha. Let's put it on social media, hee hee ha ha. All fun and games until they slap that time on your ass. At that time.
it's also clear from the and that it was for second on the 29th. Both defendants were aware that he was searching ammunition on his phone at school instead of reacting to that as a concerned parent and worried about well next time don't get caught.
Mad, just don't get caught. Fun and games. Remember all the fun and games? Remember all the fun and games? Slap that time on your ass. That's what I was referring to. You laugh now, but then you're gonna be laughing when they slap that time on your ass.
And then obviously on this very tragic day, on the 30th, they were called to the school and about their son's drawing, which clearly depicted threats and acts of violence. And instead of disclosing to the school, they chose not to take their son home. They chose not to tell anybody that might be dangerous when it was clear and they had every likelihood that he was, and instead they left. Furthermore, after the active shooting announcement went out, Mrs. Crumbly texted her son to his home purposely to search for this weapon because he was afraid his son had the weapon and was, in fact, we know he's exact terrible murder and shooting, and it has affected the entire community.
Yes. They called him in because he's drawing, he killing shit and all that, and shooting and all that. And when they looked at it, they didn't say we're gonna take him home. They didn't say nothing. They didn't even say they didn't worried about it, and they, you know. But just a couple of days ago, they had the gun range. The mother talking about, I bought this for my baby as a Christmas present. You put it on social media, and then they tell you your son is over here writing shit, and you know that you on your mind or whatever, but you know you need to get that off your mind. You'll ruin your entire life. Dumb shit. But what they did was it let the son go back to class. But here's the thing. Understand is with all these school shootings going on, you find a letter like that or a drawing like that, suspend the kid. That's what's going on in the kid's mind. But you the kid for if the shorts are too high, if you don't like what kind of colors they wearing, if their hair is too long, or whatever it is, you had no problem suspending a kid for that. But let a kid, you know, and they start killing us some shit, and you just let them go right back to class. That's unbelievable to me. If I was a parent that got a parent of a child that got killed that day, tell her what I would do. Ain't no telling.
And these two individuals
Oh,
could have stopped it, and they had every reason to know that he was dangerous, and they gave him a weapon, and they allowed him free access to it. The purpose to secure further court, and yesterday they marched with the voluntary manslaughter. Now, Your Honor, the communication between the text message that was sent to me and was not replied to. And you know, we don't have an obligation to operate, and there are good reasons for that. And I think the fact that the events that played out show the reasons for that. Now,
what she's talking about is the lawyer have conversing back and forth with each other. And you go see why she's gonna mention that. She was like but she probably foresees say what the defense attorney is about to say, and so that's why she's preemptively saying that they sent me a text message that was not replied to, telling her I didn't reply because I don't have to.
Mrs. Smith, clearly her clients did not tell her the truth, because her representation was they wanted to turn themselves in, and that they were on their way to do that. However, they didn't turn themselves in, and we were found, except that yesterday morning they withdrew in Rochester Hills.
You're supposed to be out of town. What the hell you doing in Rochester Hills, where the fuck you live at? You're supposed to be out of town. You know, criminals is not the most smartest motherfuckers on the planet a lot of time, and that's a stupid thing to do. You tell people that want to arrest you that you out of town. You go get $4,000 out of the ATM. I don't even know how you get $4,000 out of the ATM. I think my limit is like 500. I don't know how you get $4,000 out of the ATM. But if you did get $4,000 out of the ATM, uh, they
Very close to the part where they could have turned themselves in. No, um, no efforts on behalf of law enforcement. They, their location were eventually tracked down after they parked their car somewhere. A witness saw it, and with multiple other law enforcement agencies went into and searched it from top to bottom, and tools were found locked somewhere in a room, hiding. These are not people that we can be assured on their own. And then last,
they were hiding in the building. They had find. Now you want bail? You got $4,000, like, cause I think they bring it up later, but Michigan has a international airport. What you was gonna do with that $4,000, homie?
pursuant to MCR 106, we also there are none here. In fact, there are none here because there's not one committee that will vouch for.
Some shit for them. Ain't nobody coming. But BB Cross asks, can the son have a state's witness against the parents to lessen his sentence? Just asking because about this legal stuff, except what about this or what else? Okay. Yeah. The only time, the only privileges you have is if you're your spouse. Like, a wife is a husband, and a husband is not obligated to testify against a wife. However, you can do whatever you want to do. It does. You have privileges. You can forego those privileges. Like, for example, sentencing. For example, if yeah, um, you can have multiple cases on multiple different dates and all that, and let's say some type of a strikeable type of offense. If you go to trial and lose, you can only get one strike, no matter what. I don't care how many times you go back and forth on the different days. Let's say you had a armed robbery is a strikeable offense. And let's say you did it on Monday, Friday, Saturday, and Sunday. Okay. And let's say that initially they found out about the ones you did on Monday and Wednesday, trial, and then after they convicted you, they gave you one strike and whatever time associated with those two robberies, right? And let's say that after they uh, convict you, send you to prison, then later on they find out about the ones you did on Saturday and Sunday and whatever other day, right? They can bring you back and send you to court, but they can't give you another strike because they all happened during the same period, and they all happened before you. So if you did 5 armed robberies, they only find 2 is again, they find 3 more later because they convicted you of the first 2, right? Whatever date that is, right? It's gonna be after the subsequent robberies that they find out. So the strike law is based on recidivism. Fucking Jesus Christ! I can't listen. I'm getting a new eye, and I can't wait because this one right here is not built on here. This is great. Go. I'm getting a new iPad on Monday, so just bear with me because this one right here is trash. It's old. It's for the 2018. So just bear with me, please. So anyway, back to what I was. You get 5 robberies. They fought the first 2, and then in a 1 strike because they all happened before the conviction. No matter what happens, when they find out about the other ones, whatever, you have a conviction date, and anything that came that was prior to that conviction date, as far as shit, but they can't add more strikes because again, strikes is for recidivism, crimes, whatever. Now forfeit that they knew they find out about all 5 of. We're only here's the deal. We're going to give you 8 years with 80%, and then we'll get 2 strikes. Now they could, if you went to trial, you couldn't get 2 strikes, but you can agree to it, which is what I thought was amazing because you can agree to be more punished or punished further than you could actually get done legally. So you can actually agree. You get 1 more, and a lot of people don't know that, right? But that's what I'm saying. Agree to whatever. You can agree to whatever you want to agree to, whether or not it's legal or not. You can agree to it. That's what she's talking about.
So I'm asking that you set a $500,000 bond for both defendants, cash surety.
I'd like to hear from the attorneys, address that as it relates to Jennifer Crumbly first, please.
Your Honor, the first thing I need to do is to respond to the prosecution's about,
Oh, but my, I'm sorry, I'm, because BB Cross said, can the son turn state witness? Because you can agree, testify, you can. So that's what I agree. I leave that monster. Absolutely, 100%. Those parents are done. I would say so, unless guy to get some, defense attorney, which it doesn't look like they're gonna do. See, that son should. It's because they were probably trying. Absolutely.
her office. I texted Karen McDonald and told her, representing the Crumbleys, and we could talk first thing morning. First thing Friday morning. I also Layman. I also called her office. I talked to her personal secretary and explained circumstances and that I needed to speak with Miss McDonald. Marielle Lehman also called Miss McDonald in the morning. We called the prosecutor's office throughout the day and never got a call back. We were going to have our clients turn themselves in. I was in a trial in circuit court in front of Stephen all day yesterday. Miss Lehman was traveling on a plane from Florida up to Michigan. The prosecutor's office, instead of getting back to us in any way, decided to have a press conference, and as Miss McDonald try to find a way to surprise our clients and catch them off guard when it was so unnecessary. And
Wait a minute. Do you hear the white privilege in that? Are you fucking serious? You are talking about how you tried to contact the prosecutor and make arrangements in terms of convenience so that we could turn our clients in? And you never returned our phone calls. You never do anything. What the fuck? What's that? Oh, they do it here. Oh. Like, how dare you not answer my text? You didn't answer our phone calls. I spoke to your personal secretary, and you didn't do nothing but go on camera and do a press conference. Where they do that at? Please tell me. Listen, if you're wanted, oh man, hell no, they ain't got no money in cash. Hell no. It must be nice. Must be nice. Listen, if you're wanted, when you get to call the prosecutor and say, look, I need to holler at you because we need to come to an agreement as to when I can turn myself in. Ain't that a bitch? And then she's really telling the judge, like, you didn't return my fucking phone call. Judge, she never returned our phone call. We tried, but she didn't turn our phone call. Lord Jesus Christ. They were evading, and all they had to do was go into the jail if they really learned themselves in. 100%. But listen to the defense attorney. That's why that's fine. Judge, she didn't return our phone call. What were we to do?
and throughout the day, we checked with our clients. They were scared, they were terrified, they were not at home, they were figuring out what to do, getting finances in order.
Yeah, they were not home in an abandoned building or something, right? Getting finances together. They were drawing $4,000 out of the ATM. Are you fucking kidding me? She's doing this with a straight face, and she's doing this with a straight face. No, look, yes, to the naked eye, yes. Right? The defense sounds crazy, yes, but she's coming up with this stuff based upon white privilege, right? And she has to figure out a way to make good. So I get what she's trying to do, but like just like we saw in Brunswick, Georgia, when they like pastors, it's like their own, their own feelings about stuff. It comes out when they're trying to with the explanations and all that. That's they're trying. I mean, they're trying the best they can. This so she's saying we called, did this and that, and other, blah blah blah. When they had the FBI looking for you, they had a $10,000 reward out for you, and you're talking about, well, we didn't turn on shit. They didn't walk lines. We tried to reach out, and you didn't answer the phone, and that's why they turned themselves in.
In the last text messages we had with them and phone calls Marielle Lehman and I had with them, our plan by district court this morning because to start at 8:30 for any county arraignment, and we had plans to meet them at 7:30.
We had plans, plans, because if court started,
To text you to
come on, man, are you out of your mind?
8:30, so they could be arraigned. Those were plans made and solidified, and we didn't announce it because of the prosecution pending to make this That's what you need. It's 8:30. Our parents wanted to know they were fearing their life, and they wanted to just the money, and you know. case absolutely worst case The claim it's in all multiple times. She is an employee director of a large company, director of marketing. Money. Executions, facts they're presenting, which are incomplete, very incomplete. It does sound like an absolutely egregious wrongdoing on the gave their child a gun and encouraged them to do this. That's just not the case. And Mrs. Crumbly is presumed innocent. That full discovery has not been available and that the court is only aware of the facts the prosecution has presented. But that gun.
Comments because this is a good area. It's the iPad because I done burn up all my data. I can't use the computer. So just so happens that's why I was saying, like, I'm trying to get used to doing this shit, right? This iPad is trashed. I've never tried to go live on this iPad. I can't because when I touch read off I can't put it on the screen because it's gonna fuck it up. And I promise you I'm getting a new one on. Deal with this shit again. I mean, I've been here before. Like, it's just, it's just, it is what it is tonight. So, but BB Cross says, pick a better spot, please. Internet is really bad tonight. Device 2. I got 18. I promise you, get
That's not true. We need to have our clients have to over is going to see what this court has been made aware of. And for that reason, Your Honor, I ask this court to set back all of that and to absolutely avail themselves to be heard, to absolutely obey the conditions listed by present to client charges are as everyone else. It has to come from a place of legalness, not emotional reaction.
But you tell me that legal soundness, not emotional response, is is a four kids, children are dead, and they're dead. It's on their part. It's not a response. That's legal soundness. Because children here, son did. Say, I bought it for my baby, so a Christmas present. The addition, drawing that he made, the victims who were killed and all that. I spend the money on clear this crap. This is crap. So, we
we're saying, I have been insane. Involved with insane.
Very was doing yesterday. Ms. Smith has said, mine and Ms. She doesn't call us back. Seriously, are tested by $100,000 is not at this point.
That would be Ms. Verify that able to upon release from open jail.
She must provide work schedule, medical appointments, and any meetings to PTS in advance. Again, that must be installed at the jail before she leaves the jail. As it relates to Robert Crumbly, the court is setting a $500,000 cash surety, no 10% bond. The defendant is not to use or testify for alcohol, recreational marijuana, or any controlled substances. The defendant is not to possess or have in his possession any firearms, weapons, or ammunition. The defendant is not to have himself behavior toward anyone. The defendant must provide a release address if he is able to post bond. If he is pretrial services, he will be monitored by pretrial services, must submit and pay for ETG, PVC, and a urinalysis in 24 hours of release from the Oakland County Jail. And a facility that is open 7 days a week, that automatically confirms all positives, provides all levels in writing. The defendant must verify employment to PTS upon release from the Oakland County Jail. The GPS tether must be installed prior to release from the Oakland County Jail in the event that the defendant is able to post bond. He also must provide information relative to employment schedule, medical appointments, or any other appointments that are allowed, which will include, he could attend court hearings, employment, medical appointments, and attorney meetings. Any violations of any of the terms and conditions of those bond may result in revocation of bond. Any questions as it relates to bond for James Crumbly?
Your Honor, we have no questions, but I do need to place one thing on the record. I'm not asking the court to change anything. What I want to state on the record is I was not able to watch the entire press release and what I had no idea there was a 4 o'clock arraignment. Ms. Lehman didn't know either. The media had so many reports of random times that quite frankly, we didn't believe there was.
So we're not going to get into.
I just want to apologize to the court because we weren't aware. And also we faxed over appearances and no one told us like, hey, we're going to do this at 4 o'clock. We sent appearances late in the day. And I just apologize to this court because we don't miss dates. So thank you.
Thank you. Finally, as it relates to bond,
Yeah, I switched devices. I got rid of that iPad. This is a 13, right? The quality does look better. But again, you know, we doing a lot of testing, and obviously the iPad not gonna work. See, the reason why I was on the iPad is because it's bigger. But I'm getting a new iPad, so I'll have the same thing. So in the meantime, I guess what we're gonna have to do, we're gonna have to go on this. This is the 13, right? But I'm gonna work with this. I think I'm a guest now. I mean, I don't even know what's going on, and it obviously looks a lot better. Again, I've never had that many problems with a device ever in the history of devices. That motherfucker is trash. I'm about to throw it out. No, I ain't throw it out the window, but I got to turn it in. But I'm getting a new iPad on Monday. So from now on, I'm gonna use this device going live because I thought I could use that. I didn't know it was that bad. Like, I mean, it's really bad. So it kind of screwed up the live, but we're gonna try to continue and get through it, and because there's still a little bit more, and then we're gonna talk about it. So just bear with me, please.
In the event that the defendants do post bond, I am requiring that they turn over any and all weapons to the Oakland County Sheriff's Office. That must occur within, realistically, I'm not sure what they have in their possession or if they're going to be able to be, where they're going to be released to if they post bond, but I am going to require that they turn over all weapons upon release from the Oakland County Jail.
As they should. 100%.
Okay, any other questions?
No, thank you.
No, Your Honor.
Thank you. All right, again, the PCC is on the 14th at 1:15. Preliminary examination is on the 22nd at 9:45 a.m. It will be in-person proceedings. Please make sure that you are prepared with all witnesses and or exhibits.
Your Honor, I just do want to put on the record that there are hundreds and hundreds of hours of digital evidence and voluminous documents, and we are compiling it, and we'll get it to defense counsel as soon as possible.
Okay, thank you.
Thank you, Your Honor. Have a nice day.
Thank you, Judge. Your Honor.
And that was that. As grueling as it was to get through, that's what it is. I'm not even on the headphone set now. I'm on the phone mic, and I don't know what the sound quality is at all, but obviously we can't do any lengthy streaming with that iPad. Again, I'm getting a new one on Monday. This is the last of it. I didn't know it was that bad. I never would have done it. I would have set this up first if I'd known it was that bad. But that thing, man, it would not. After a while, it would not do anything. So hopefully this one's a lot better. It looks a lot better. Like even just the camera part, it looks a lot better. It sounds okay. Okay, awesome. Yeah, so I guess we found out that we can't use the iPad no more. And again, the reason why I was using it was because, it's a bigger screen. I think this is what we're going to do. Let me close out this right here, and then let's come back and discuss it. That way I'll have a better mic, and I'll be able to put my other mic on here, and we'll go, we'll discuss it. It's really little, right? I don't like this because it's super little, but apparently it's better quality. Not to mention, it'll be another way to test it again because I was having so many problems with the iPad. I wasn't having it as much in the beginning, and then here, towards the end, it was a problem. So let's close this out, and then we'll come right back. And then probably like 15, 20 minutes, and then we'll come back and then we'll discuss what we heard earlier. So catch back with me in about 20 minutes. See you in a minute.